Let's talk about the litigation process in an ERISA disability case. If the disability carrier does not reinstate your benefits after an appeal, you have really only two choices. You can give up and let the disability carrier win, or you can file a complaint in federal court. Why in federal court? Because most ERISA disability policies are governed by federal law. Now, why do I say most? Because there are some exceptions. Those exceptions include plans that are issued by a municipality, such as a county or even a state, city, or a policy is issued through a church plan. In that instance, it is not an ERISA policy, it's a state breach of contract type case. So let's say we find ourselves with an ERISA policy or plan. The carrier has denied your appeal. What happens next? Well, you should be hiring an experienced ERISA disability attorney like myself to file what's called a complaint. I like that word, complaint, because there's lots of things to complain about in an ERISA disability case. The first thing you're going to be doing in a complaint is you will do what's called an allegation of basically the facts. The fact that you're a disability policyholder, that you've met the conditions for filing a lawsuit, that you have filed an appeal, the appeal has not been successful, you've exhausted your administrative remedies, that you filed a claim, that the claim's been denied, you filed an appeal, that's been denied, and you want to set forth the allegations that establish medically, factually, why it is that you are disabled. And as part of that, part of the pleadings, we also allege whether or not you've applied for and are receiving Social Security disability benefits. Now, this part of the complaint can be very factually dense, or it can be sort of a cursory type of allegations. And what I do really depends on who the carrier is, who the judge ultimately might be in the potential district that I'm going to be filing my suit in. The next part of the complaint is about your remedies. And unfortunately, in the ERISA world, there are limited remedies that we can ask for. We're asking for primarily reinstatement of your disability benefits. We can't ask for ongoing benefits because each month is a new claim, and the judge does not have the jurisdiction to award an ongoing claim of benefits because that's not in dispute. Now, we're also going to be asking for the reinstatement of any ERISA benefits that you've lost. What's an example of that? That might be a life insurance policy because you might have what's called an LWOP, a life insurance waiver of premium. Generally, the insurance company will not require you to pay your premium for your life insurance so long as you are getting your ERISA disability benefits. But once they stop, they will basically either make you pay those benefits or potentially you can lose the life insurance benefits. So if you don't pay the premium, we're going to potentially have a problem with that. But in any event, in the complaint, I want to be asking for reinstatement of ERISA lost benefits. I'm also going to be asking for prejudgment interest, and I'm going to ask that they pay the attorney's fees. The reality is that unless we're successful in front of the judge or we are successful in getting them to voluntarily reinstate benefits, it's going to be tough to get the court to award fees at the expense of the disability carrier. There's a multi-factor test that the judge has to run through to determine whether or not the conduct of the disability carrier is sufficient to award fees at their expense. But of course, I'm always going to claim it. That complaint, as I said, can be a very detailed complaint. It could be a cursory complaint. Regardless of the nature of the allegations, the complaint is going to be served on the defendant insurance company. And service is basically a legal means of delivering to the insurance company the complaint. So what happens after that? We'll tune into the next episode.